Okay, Azam,
Okay.
10 seconds.
Good afternoon, everyone. My name is Azam Nizamuddin. I'm an attorney and also a candidate for the Circuit Court Judge in DuPage County. We're really happy to have you join us for another informative Facebook Live webinar. And today, in particular, we have a very timely event and a special guest with us. We're going to be talking about the Supreme Court of the United States with Professor Aziz Huq of the University of Chicago. We have about an hour, so we'll discuss a little bit about the recent cases as well that have come down. As you know, this was a very lively term of the Supreme Court, which began in October, and it just ended this week. So in order to get started, I want to introduce my special guest today, who I had a chance to work with before on a couple other occasions. With us is Aziz Huq, who is the Frank and Bernice Greenberg Professor of Law and the Mark Claster Mamelin Teaching Scholar at the University of Chicago. He's a 1996 graduate from the University of North Carolina as a summa cum laude and a graduate of Columbia Law School, where he was awarded the John Ordonaux Prize. After law school, he clerked for a Court of Appeals judge for the Second Circuit named Robert Sack, and he also clerked for Supreme Court Justice Ruth Bader Ginsburg, which is one of the very few positions, elite positions offered to law school students and graduates. It's a really high honor, and it's a very, very competitive position to be able to get that. So currently, he is at the University of Chicago, but before joining the faculty at U of C, he was the Associate Counsel and Director of the Liberty and National Security Project for the Brennan Center for Justice at NYU Law School, where he litigated cases at the federal courts. He was also Senior Consultant Analyst for the International Crisis Group. And his teaching and research interests include constitutional law, criminal procedure, federal courts, and legislation. He's published a couple of books as well. One, which I'm sure many of my viewers will be interested in, called How to Save a Constitutional Democracy. And that was published by UFC Press in 2018. And then also Unchecked, Unbalanced Presidential Power in a Time of Terror. Anyway, how you doing, Aziz?
I'm doing well, Azam. Thank you very much for having me on this webinar.
Well, I'm delighted to hear you speak. I had you come on for a couple of presentations, I think, for lawyers before on other Supreme Court decisions. So it's really a pleasure to always hear you. I'd like to get started before we dive into some of the cases and so forth. I'd like to just get a little bit about your background for our viewers who may not have heard you before. Can you tell me a little bit about where you grew up, and I'll ask a few more questions and things like that.
Sure. I grew up in the United Kingdom. I came here to the United States for college. The University of North Carolina has a very generous scholarship program, which I was lucky enough to be able to participate in, and then stayed after college to go to law school, as you said, at Columbia. Really, it was at Columbia that I started to become interested in constitutional law as a field. I had been very focused previously on international human rights. I'd worked in Guatemala as a participant in investigations into war crimes that occurred in the 1980s. At Columbia, I really experienced for the first time some of the tremendous both intellectual and ethical challenges that are presented by constitutional law, and seeing how those were challenges that one could pitch in and be involved in and grapple with, not just as a judge or a law clerk. And as you said, I was fortunate enough to have two terrific mentors while I was a law clerk. It's also a field and a domain of law that you can grapple with as a practicing lawyer, as a judge, or as a citizen. I have really enjoyed my experience, not just as a clerk, not just as a lawyer or a law professor, but really as a citizen, building on my knowledge and understanding that I started to seed at Columbia Law School.
Mm-hmm. Aziz, let me do a little deeper dive into your background and ask you where your parents are from.
My parents are from Bangladesh, but they'd moved to the United Kingdom. As I'm sure many are aware, there were large migrations from the Indian subcontinent toward the end of the Commonwealth period, particularly through the 1960s and 1970s. My parents were part of those migrations. And so they were in England before I was born.
And were they also of a professionally with a legal background, or were they more in the kind of sciences and so forth?
No, my father was retired, but is a psychiatrist.
Okay. Now I have to ask you this because, this is the typical question that people like you and I of South Asian background get is, what possessed you or I to go into the legal profession? Because as you know, by virtue of our ethnic background, we're supposed to either become doctors or engineers. So I have my own story to tell, which I've sort of discussed with some of my viewers in the past, but I was curious as to what led you into the legal profession.
I became interested in law as a consequence of working while I was in college with a professor actually in the religious studies department of the university I was attending, who was looking at social activism in Central America around human rights violations. And through work with him, I acquired a position working with a not-for-profit in Guatemala City that was conducting exhumations of mass graves left over from the Guatemalan Civil War at the beginning of the 1980s. So part of the time between my college and law school experience was spent in rural Guatemala, both doing mass exhumations and then helping the widows, mothers and sisters of those who'd been murdered get death certificates and paperwork that they had been denied for decades in relation to their murdered kin. The experience of that work, which by no stretch of the imagination can be described as fun, was for me a deeply rewarding one. I felt that I was able to give back to people who were really desperately in need of help. And I was able to do that by leveraging even the small measure of legal skill that I had at the time. And going into law, both at the beginning and even now, when I do largely academic work, but also some pro bono work, my view of the law is as an instrument whereby one can have both a satisfying professional life, but one can also meaningfully contribute to the good of humanity by helping people who are marginalized, subordinated, violated, and otherwise wronged, often by the state and its agents.
Mm-hmm. It's interesting. When listening to what you just said last couple of minutes made me think of the same view that, I don't know if you know Michael Tiger, who is a very prominent criminal defense attorney, but also a professor of law at Duke, who once said that the tools that lawyers develop, both in law school, but also in the practice of law, the analytical abilities and the knowledge of the law, that their best use is used against instruments of governmental power that try to deprive people of human rights, and also that sort of deny basic constitutional and democratic rights. So it's very interesting that what you said in terms of what motivated you to go into the law and what really compels you to help people out and so forth. Now, in my introduction of your background, I mentioned that you clerked for Judge Ruth Bader Ginsburg, who's a really important role model for women. And I know there's a lot of viewers out there who would be interested, do you mind sharing just a little bit of background of what that was like to clerk for her during your tenure as a law clerk?
Well, I think Justice Ginsburg's a role model for many people. Absolutely, you're right to say that she's a role model for many women. I know for many girls who are my children's age, she's someone who is an example of how public service as a lawyer in her time at the ACLU, where she litigated many of the really vital early gender equality cases, and also as a judge, where she's written some tremendously important both majority opinions and dissenting opinions, has been it's a really crucial role model. For me, my experience with her is very much the experience of the law clerk who is learning how to work with and live in the law. Those of you on the call who are lawyers of long standing, who've experienced either litigating in court, on your feet or on papers and in an appellate context will know that it takes an immense amount of labor and an immense amount of work to acquire the sense of what works and what doesn't work. What is a timely and effective argument? What is things that you can say and can't say? And a clerkship is an experience in which that learning is immersive and accelerated. And so I think for me and for many people who clerk for Justice Ginsburg, I think this is true maybe for other judges and justices too, the sense of how the law feels and works, one's own sensibility as a lawyer is the thing that is being shaped and transformed as you work with a judge or a justice. And so my experience, which I think it was well known at the time, I'm not sure if this is still the case, that the Ginsburg clerks would work longer hours than any other clerk. And she was a extremely meticulous, extremely comprehensive jurist who wanted every case, every fact, every I dotted, every T crossed in her work. Learning how to do that and learning how to meet her extraordinarily high standards, rightly high standards, was the thing that I learned and really took away from that clerkship.
Well, that's fascinating. We don't hear about this in the public press about the experience that law clerks have. Another question that I sort of had is, in terms of ideology of Supreme Court justices, you sort of hear about the view of someone like Antonin Scalia, who is often labeled as an originalist or maybe a textualist, and as well as Justice Thomas. I would think that they would fit in that sort of categorization. And then you had Justice Brennan, from many years ago, who was kind of viewed on the opposite spectrum, someone who believes in the living Constitution, who believes in the evolution of development of the law. In your sort of observation, how would you sort of characterize where Justice Ginsburg fits into that kind of framework?
I think that these labels, originalist versus living constitutionalist, are more misleading than helpful when it comes to judges. There is no sitting federal judge or justice who does not care deeply about the understanding and meaning of the terms that were adopted into the Constitution and came online in 1788, and then in the 1865 to 1869 period with respect to the Reconstruction Amendments. Everyone cares about original meaning, and no one thinks that original meaning settles every question. No one thinks, for example, that the text or original understanding of the First Amendment, and in particular its speech clause, tell us how robocalls should be regulated. That was an issue before the court this last term. nobody thinks that, or nobody sensibly thinks that the original understanding tells us how to square the competing demands of anti-discrimination law, which is something that's emerged only in the last 50 years, and a corporate entity's right to religious freedom with respect to the kind of health insurance it supplies. So every justice is balancing and drawing upon both original understandings and original meanings on the one hand, and the demand or the necessity that the law be understood in ways that have practical traction today in respect to problems that are presented today, and in a way that is faithful to the abiding values that stand underneath the law. So I think that the disagreement about who is an originalist versus who's not an originalist is more of a smokescreen than anything else. I think it's an argument that's been made, particularly on the right, as a way of criticizing opinions that judges on the right, people on the right, don't like. But I think the real disagreement between the judges and the justices is not over method. The real disagreement is in thinking about how to apply abstract legal texts. You have to think about what values and social aims they further. It is impossible, for example, to think about the free speech clause without taking some account of the kind of society in which speech is free. Same is true for the Second Amendment. The same is true for principles of federalism or the separation of powers. And really the disagreement between the justices is a disagreement that is about the way in which those profound values are understood, weighted, and carried forward to contemporary situations.
That's very interesting. So that would, I think, what you're saying sort of explain, perhaps, particularly this term, where people on perhaps the right were disappointed quite a bit. Let's just say people who are deemed to be conservatives or people on the right who may have been disappointed with some of the opinions by, say, Justice Gorsuch or Roberts on some of these, issues, hot button issues, who felt that, they're going to take a certain position this way, but in fact, they didn't in terms of what they anticipated, particularly as it relates to, some of the issues regarding the LGBTQ case, Bostic, which we'll get to in a few minutes, and things like that. Perhaps that's why, because of these sort of, presumptions of ideology that people in the public sphere and in the newspapers and media kind of attach to the justices.
Yeah, I think that's right. I think that I think that people are, however, are not incorrect when they label judges or justices as liberal or conservative and anticipate certain kinds of votes from those justices and judges accordingly. And most of the time, the empirical social science tells us those expectations turn out to be true. Most of the time, judges and justices vote in line with roughly what you would think their ideology is. One of the things that has been very interesting about this term is the scrambling of ideological signals. Now, in some instances, I think that there's a kind of political explanation for that, and I'm happy to talk about that. And then in other cases, I think it is, I think there's something more interesting and more puzzling going on. And maybe when we talk about the particular opinions, either at your prompting or if I remember, I can say, well, here's a justice whose vote is very hard to explain.
Mm-hmm. Sure. Okay, so let's dig a little deeper and just kind of talk a little bit about the approach of the Supreme Court generally, right? In other words, what is the role of the Supreme Court in our form of government? We sort of labeled our talk, a third co-equal branch of government. Mm-hmm. But if you read some of the opinions, depending on who they are, oftentimes there's a view that says, the Supreme Court really is not equal to, for example, the executive or to Congress. And that's why it's Article 3 and not Article 1. That it kind of was deemed to be an afterthought by the framers or the founders. And this is an opinion for, I've read amongst both the judiciary, but also certain thinkers. And therefore, it's really Congress and the president that make law, and the Supreme Court is supposed to kind of leave it alone and just simply interpret it based upon the textual understanding and things like that, and not do any kind of legislation. And I just want to kind of get your comments about both the role of the Supreme Court in our sort of tripartite system of government, and whether it's evolved in any way in the past, since the founding, really.
Sure. Let me maybe answer that question by leaping off from the last point that you made about the evolution of the court. When the court first met, which I believe is in New York, in I think it was 1791, 1792 is when, after the first Judiciary Act had been passed by Congress. There were 5 justices who were selected. They were supposed to meet in New York. Not all of them turned up. And it took a while for people to start bringing cases to them. And for a long time, the court was a kind of minor appendage, even to the much smaller post-colonial state of the 1790s. All of the action was Congress and the executive branch. So you have figures like Oliver Ellsworth, who was an important founder, was appointed briefly to the Supreme Court, leaving the Supreme Court at the end of the 1790s because it's a backwater as far as national politics go. This starts to change only under the famous Chief Justice John Marshall, but even then, it starts to change slowly. And it is only in the post-Civil War period that we start to see the Supreme Court flexing its muscles. Only after the 1870s does the court start to invalidate a non-trivial number of state and federal statutes. And this ends up accelerating in the progressive era and increasing in the post-New Deal period. So the court that we have today, which if one looks at its docket, it feels like every single issue of large national importance somehow ends up before the Supreme Court, be it, how our elections are run, what kind of health coverage we get through our employer, when and how governors can close or open gatherings or large facilities during the pandemic. All of them end up before the Supreme Court. That is a relatively recent development in the court's history, the sense that the court is a co-equal branch in the sense that it's taking on as many or more of the central national issues of the day than Congress. I actually think is a quite new thing that dates from the last 50 or so years. Wow. So the court really has transformed over the course of American history, and the sense of what it can do in terms of settling constitutional questions has dramatically changed. I think if you had asked most of the justices in 1801, what's the chance that every single major piece of legislation that Congress enacts will be subject to some kind of judicial second guessing, they would have just laughed at you. They would have said, "This is crazy. We're not. This is never going to be the role of the court." And yet here we are. So I think it is a mistake to think of the court as a static institution. Just as we all know that the American state of 2020 is radically different from the American state of 1791, so too the courts.
Great. That's a very, I think, important explanation of the development of the court, but also where it stands, because I think a lot of people don't really know that history. Even many lawyers, I bet, don't really know that history, because particularly if you've been removed from law school for a long time. So Aziz, with having said that and giving that nice foundational background, let's sort of hop in and jump into some of these cases. And I'll begin by asking you what your thoughts were most recently in this term about the two cases dealing with presidential authority and power, the power of the executive. And these really came out in two sort of twin cases called Trump versus Vance and Trump versus Mazars. Mm-hmm. This, of course, had to do with both the sort of local district attorneys and also Congress's subpoena power to the president. And I wanted to get your feedback on these two kinds of cases.
I think these cases, Azam, are really the most important cases of the past year. I think these are the cases that people will be reading in 20 years. And I think that because they're cases that go to the heart of how our constitutional system works. In both instances, what's at stake is whether and how presidential papers, here it's actually papers that largely are of a personal rather than of an official nature. Mm-hmm. These are financial papers produced by Donald Trump when he was not president, by the Trump Organization, or by members of the Trump family. They're sought by three different congressional committees on the House side and by the Manhattan District Attorney, Cyrus Vance. And the issue in this pair of cases is whether another government branch can obtain forced disclosure of the president's papers. The key line in these cases, and it's a line that is articulated in one form or another by both Chief Justice Roberts and Justice Kavanaugh, is in our constitutional system, there is no person who is above the law. That is a tremendously important legal principle. It is the principle that was at stake in the president's claim that he was under no obligation to comply with either Congress or a criminal grand jury's request for papers. The court in these two opinions soundly rejected the president's claim to stand apart from Congress or the criminal process on the basis of merely his possession of the office. And this is a tremendously, I think, important decision. It was very easy to imagine this decision going the other way. One of the lower court judges in this case, in the Mazars case, Judge Naomi Rao of the DC Circuit wrote an opinion which would have, I think, effectively ended all congressional investigation of either the president or the administration. Right, that I think is what was at stake in these cases.
Wow.
And what's really striking about these cases is the fact that both Mazars, which is the opinion about congressional subpoenas, and Vance, which is the case about the District Attorney of Manhattan's subpoena through the grand jury, both of them are 7-2. Right, 7 justices, including both of President Trump's appointees, Neil Gorsuch and Brett Kavanaugh, voted to reject the categorical claims of immunity from discovery that the president was making. And that's, I think, an extraordinary outcome. The immediate response to these opinions has been, well, we're not going to see the tax returns this year, which is right. We're probably not going to see the president's tax returns. I'm not sure there's an actual living, breathing human being in the United States whose opinion of President Trump would actually change based upon the tax returns.
Right.
At this point, I mean, where is this person? Have they been, hiding in a cave in Yellowstone Park for the last 3.5 years? So that issue of the tax return seems to me just utterly beside the point. What's really at issue is moving forward, will Congress and will criminal grand juries and prosecutors be able to get evidence when it touches upon the president? And the answer to that is yes. And that is tremendously important, particularly in light of the fact that we had an impeachment process where there were very serious and, in my view, quite well substantiated allegations of serious wrongdoing.
Right.
And it's not so much the vote that troubles me, it's the fact that there was simply no serious evidentiary process in the Senate.
So let me follow up on that with you and ask you, look, I think at the time that we have been raised in the past 40, 50 years, there has, I think, been a prevailing view that the president, regardless of regardless of which party, whether it's Nixon, in particular, I would say, actually dealing with Nixon, we've sort of assumed that the president is not above the law. In other words, when it came down to President Nixon being able to maintain his White House tapes that he was recording of conversations, he had to. The Supreme Court said you got to turn it over, and so on and so forth. And the whole presumption of an executive was created to make sure that it would not emulate King George III of Britain, so that there was a sort of supremacist executive, right? So in other words, at least my assumption, I think other people's assumption would be that the president is subject to powers of federal legislation, for example, and other things. So if that be the case, why should this decision be so important, number one? But number two, how the heck was this decision not 9-0?
So I think that there's a couple of things that are important in understanding the context of this decision. The first is that since the early 1980s, there has been a concerted movement, mostly among lawyers in the Reagan, Bush 1 and Bush 2 White Houses and Justice Departments, but also among scholars and in public policy activist circles, to dramatically expand on presidential power. Maybe the most well-known explanation for this movement was given by Dick Cheney in the early 2000s when he said, look, Watergate was a disaster for the American presidency, not because of what Nixon did, but because it led to the presidency being constrained by law and by protocol in a whole bunch of different ways. And what we need now, said Cheney, but I think he was speaking for this entire movement, was a wholesale stripping away of many of the constraints upon presidential authority. Part of this movement is based upon a sense of the priority of the things that the president does as opposed to the things that other branches do. So it's a sense that national security and acting expeditiously on national security just matters more than anything else. Mm-hmm. Part of it, though, is a contempt for deliberative democracy through groups, which is messy, difficult, time-consuming, as anyone who has been in a local board or a council, let alone on the floor of Congress, knows. So there's a sense of, look, we can just cut through all of this chatter and get straight to the point. The reason it's surprising that it's, to be honest, I was expecting, the best case scenario that I was expecting was a 5-4 decision that Congress could proceed with a strong 4-person dissent saying under no circumstances can the president be subject to compulsory process to reveal his legal papers. Mm-hmm. And the reason I was expecting that is because several justices on the court are part of this long-standing movement for presidential power that I just described. Mm-hmm. So I think that's an important piece of background. The other important piece of background, why this is so important, is that there are other domains in which the court has declined to push back on presidential assertions of authority. For me, personally, and we've talked about this before, the case that most recently exemplifies this in a very troubling way is the Supreme Court's decision in Trump v. Hawaii about the travel ban, where the court essentially said, yes, we recognize that the president has engaged in Islamophobic speech before and after the election. We recognize that Islamophobic speech is linked to the promulgation of the travel ban. But so long as we can conjure up, so long as we can imagine a rational basis for the travel ban, we'll allow it to proceed, precisely because of the deference that we owe the president's office, not the president's person, but the president's office. Mm-hmm. So I think the travel ban case is a real example where you have a real stepping back from important constitutional norms in a way that allows, and both did allow and still does allow, travel ban still in effect, the president to behave in really lawless ways.
Mm-hmm. Do you think that the justice, just really quick, in that particular case, gave deference to the executive was because it dealt with immigration law or the ability for the president to determine who gets in and who stays out?
I certainly think that the president is on strongest ground making claims of unilateral power when what's at stake is either national security or immigration. I think he's better off on national security than on immigration. Although there was an important case this term that upheld the practice of expedited removal of immigrants without any judicial process. Okay, and that's an example of a case in which, in the immigration context, the president gets leeway that I think would be impossible to imagine in other cases. Right? In that case, the president has leeway to simply seize somebody and without any judicial process, deport them to another country, right? Mm-hmm. And this in a context where a non-trivial number of expedited removals and deportations out of the country occur as against American citizens, right? If you're a Hispanic person and you're subject to expedited removal, you happen to be a US citizen, but you're not walking around with evidence of it, right? There are many, many cases in which erroneous expedited removals happen. So this is a really, this is a significant thing. This is a significant phenomenon. The idea of unfettered executive discretion that it embodies, yeah, it's strongest in the national security and in the immigration context, but it often spills over into other domains, right? And we see it playing out a little bit in other domains.
Well, that leads me to a question that was just posed relating to this, which is about elections. What happens, for example, if the executive loses the upcoming election and challenges the results, claiming that there's voter fraud, and refuses to sort of, leave office at that particular time? Is that a process? Well, obviously, I guess with Bush versus Gore that occurred in 2000, maybe the courts will get involved. And at that point, maybe because it's removed from national security issues and removed from immigration, perhaps the president may not have as much deference. What are your thoughts on that?
What you've described, I think, is a scenario that the Constitution does not directly address. Contested elections, some may recall, are not supposed to be settled in the courts. That's actually the House of Representatives' job under the original constitutional design. And indeed, the 1800 election, which resulted in a toss-up between Aaron Burr and, I'm sorry?
Adams and Jefferson?
No, it was the Adams and Jefferson election, but it resulted in a tie between Jefferson and Burr because under the pre-12th Amendment system of electoral college vote casting, everyone who wanted a Jeffersonian presidency had cast a vote for both Jefferson and his vice presidential candidate, Burr, which meant both Burr and Jefferson had the same number of ballots, right? And when you have the same number of ballots, which nobody had expected, the election gets thrown to the House of Representatives. The House of Representatives ended up voting more than 15 times on the election. Burr, as anyone who has seen Hamilton will know, engaged in his usual machinations, right, and tried to get people to swing his way. The governor of Virginia threatened to take up arms if Burr was elected president. It was a real crisis, but it was a crisis that found its cockpit in the House of Representatives. That's where contested elections are supposed to happen. Mm-hmm. Now, what would the House of Representatives today do with a contested election?
You know what? I should have known the answer to that because I just watched Hamilton a week ago.
Yeah.
So with my family. So, and it was Burr versus Jefferson, and according to the release of play, was Hamilton that cast the winning vote.
Yeah.
In any event, okay, great. Well, this is fantastic. Let's move on then from presidential powers to some other cases that are kind of important. And let's talk a little about civil rights in the employment context, where there are two major decisions that really came down. One, of course, was the issue of the rights of LGBTQ and transgender employees, right, and their ability to bring claims under federal law, and in particular under Title VII of the Civil Rights Act. And you had the Bostock case versus Clayton County, which was really three different cases that came together.
Yeah.
Two dealing with people who were LGBTQ, and the other was the transgender case. So there's three actually that came together.
Two gay plaintiffs, one trans plaintiff.
Exactly. So what are your thoughts about the Bostock and Clayton? Were you surprised? What did you think about that?
Yeah, I was surprised at the outcome. I was surprised that it was just Justice Gorsuch who wrote it. The opinion claims that that its conclusion that gay and trans discrimination is forbidden under Title VII, which is the standard federal workplace employment discrimination law, follows kind of mechanically from the text of the statute. And Justice Gorsuch goes through great lengths to show this is just, I'm just reading the words, and the words say because of sex. And if you fire somebody because they are attracted to a member of the same sex, you are firing them in part because of their sex. If you took sex out of the explanation makes no sense, is his point. And that's entirely right as a semantic matter. I think the problem is that, yes, there is tradition in the federal courts of reading the text of statutes just to mean what their dictionary definitions suggest they mean. But there is an equally strong tradition of saying, well, we look at words and we think about and ask, what do they mean in the context in which they were enacted? You can think of this as originalism for statutes. And, as Justice Alito's dissent, I think, very powerfully says, no one thought that this statute covered gay and trans plaintiffs in 1964 when it was enacted. It just was the farthest thing on people's minds. And so if you ask what the ordinary meaning of Title VII was, and in particular its sex discrimination provision, in 1964 when the statute's passed, it's utterly crazy to reach the result that the majority reaches, says Justice Alito in his dissent. And I will say that I am enthusiastically in favor of the outcome of Bostock, which I think is normatively the right outcome. And if I was a lawyer in the case, I would have made all of the arguments that I think the plaintiffs did make, that Justice Gorsuch for the majority embraced. But do I think that that's how people should actually read statutes? Not really. But I'm happy with the result.
I noticed a couple interesting facts about that case. Number one was that the majority opinion by Gorsuch was about 30 pages, where Alito's dissent was like 50 pages. And he began by really attacking the majority opinion, I would say, in a kind of aggressive way by saying that this is this is really legislation, that the decision of the majority is a form of legislation because previous attempts by Congress to pass similar legislation failed, and they should have left it up to them, or at least in particular the Senate, I think it was.
Well, the argument that a court is improperly legislating when it reaches an outcome that you don't like is a pretty common one, right? This was the complaint that was made about Obergefell, which is the decision on gay marriage. It's actually exactly the same complaint that was made about Brown v. Board of Education back in 1955, 1956 by, for example, segregationist members of Congress in something called the Southern Manifesto. Right? The common critique across time is it's outrageous what you're doing is making a normative judgment. How do I know that you're making a normative judgment and resting the law upon it? I know because I disagree with what you've done. So I tend not to be persuaded by this kind of argument, the kind of argument that Justice Alito makes, because it begs the question of how we tell the difference between reading a statute or reading a provision of the Constitution and making new law. In a world in which we have statutes that apply to endless numbers of new situations, what judges do is, in some fashion, making up the law. Exactly the complaint that Justice Alito made in his Bostock concurrence can be lodged, for example, against most of federal antitrust law. Right? The federal antitrust statute just says no restraints on trade. Right? And yet we have this very, very elaborate jurisprudence about vertical restrictions, about horizontal lockups, about monopsony, about monopoly. None of that's in the statute. Judges just made it up. Right. So, to my mind, the accusation that somebody's engaging in legislation is it presupposes it rests upon the assumption that there's some clear and distinct line between legislating and reading statutes or reading provisions of the Constitution, and that's just not the case. It's just not true.
I agree with you. I think the decision there was correct, and I think the same kind of criticism is made when someone says, well, that's an activist judge versus a non-activist judge. I guess it's in the eye of the beholder, because if you agree with the decision, then they're not activists, but if you disagree, they are activists. And the same
So, for example, is Justice Brennan activist, or is Chief Justice Warren activist when they decide Brown v. Board of Education? Well, they are activist in the sense that Brown meant the end of the form of educational system that about a third of the country was then using. That's an enormously consequential decision. How do we think, for example, of a case that was decided yesterday about the scope of what's called Indian land? Right. This is a case called McGirt v. Oklahoma, and the bottom line in McGirt is, well, the United States entered a treaty with the Navajo in the 1800s, and under the treaty, most of Oklahoma, if I'm remembering the state right, is Native American land. It's Indian land, and that means there are restrictions upon when and how the state can prosecute Native Americans. Right? Is the opinion there activist or not? It depends on your baseline. I don't think there's a simple answer to that.
Right. To kind of discuss something that's related to the Bostock case is what was the concern raised by both Kavanaugh and Justice Alito, which was the impact on employers who are religious institutions. And the impact of that was immediate in this case that came out this week called Our Lady of Guadalupe School versus Morrissey and Beru. Actually, it was a companion case as well with another case.
Yeah, Morrissey Beru is the name of one of the two plaintiffs.
Right.
Yeah.
And in that scenario, these were two employees. One, I believe both of them were women.
Yeah, both of them taught fifth grade. Yeah. Both of them were teaching and they were both employed by parochial schools.
Catholic schools, in fact.
Right. and both taught some Catholic catechism and also taught regular non-religious topics. And the question in those cases is, the court had previously said that there is an exception to anti-discrimination law for ministers, right? So the Catholic Church or a mosque cannot be sued under Title VII because it refuses to appoint a woman priest or a woman imam, right? So, and the ministerial exception is a long-standing exception. It's not in the federal statutes. It's just been carved out by the federal courts.
It's common law.
Right. What the Morrissey-Baru decision does is extend the ministerial exception to A, the context of a parochial school, and B, the context of a person who was only part-time teaching religion. They were also teaching science and a whole bunch of other things. And so the significance of that case is it's dramatically expanding the scope of the exception to employment discrimination law.
Right. Yeah, and I thought it was interesting because prior to that, I've litigated these kinds of cases because even outside of federal common law, this exception exists in state common law cases in Illinois, for example. So I was involved in a case where I represented one faction in a dispute in a mosque.
Yeah.
And it had to do with basically who's going to control the mosque. It was a leadership dispute.
Yeah.
We came in on a temporary restraining order, and one of the defenses, the defendant's argument was this exception that, I think they call it the religious, in Illinois, they call it the religious abstention doctrine. And that you can't involve the courts in these discussions. And we argued successfully that this had nothing to do with religion. It had to do with corporate governance.
Yep.
And most, at least mosques and other religious institutions exist pursuant to a charter under the Not-for-Profit Act in Illinois, for example.
Yeah.
And the judges agreed with us. But I thought it was kind of interesting because in this case, they really expanded the scope beyond the ministers and religious actors into just lay teachers as well.
Yeah, no, the court, and I'm aware of the time, so I'll say something that tries to wrap up a few cases in one go. Sure. The court, in a number of cases this term, has found in favor of religious claimants who are asserting their right to be treated distinctly because of their religion, and sometimes not distinctly. They have the right to be treated as other people. So in Morrissey-Baru, the religious school is seeking an exemption. In a case called Little Sisters, which is a continuation of a number of earlier legal challenges to the contraception mandate that's in the Affordable Care Act. In Little Sisters, the plaintiff states were challenging the existence of an exception for conscientious objectors to contraception provision, and they lost. So in that case, the religious objector gets to opt out. And then in a third case, which involved a scholarship fund administered by a state, the court held that a state constitutional rule that said state funds cannot go to support religious education was invalid as a form of religious discrimination. And so in that last case, the religious litigant isn't seeking an exception from an otherwise generally applicable law. Mm-hmm. What they're seeking is actually the absence of an exception. They're seeking to be included within a generally applicable funding scheme. And the common thread here is not inclusion versus exclusion, it's that the religious plaintiff wins.
Right. And I thought, in a sense, I thought these last couple of cases were almost trying to give assurances to religious institutions and establishments.
Yeah, it's hard to read those cases without thinking back to Bostock.
Right, right.
Yeah, no, the cases are clearly connected.
Yeah, exactly. Very good. I thought a couple more cases, Aziz, that we can sort of just mention and get your perspectives on. Of course, one is the abortion case called Russo versus June Medical Services. This is
Yep.
where the restrictions that were created in Louisiana,
Yep.
which a lot of people feared with this new conservative majority, particularly the justices appointed by Trump, that they may actually people say Roe versus Wade, but it's not really Roe versus Wade. It's really Casey, Planned Parenthood. That's the main case. Which
Yeah.
says that statutes or regulations can't impose an undue burden on women's right to an abortion.
Yeah.
People thought that it might undermine that particular case, and that was the case here.
Right. This is a case in which Chief Justice Roberts provided an unexpected swing vote to invalidate Louisiana's restrictions on freestanding abortion providing clinics. He did it because 2 years earlier, the court, in a case called Whole Women's Health, had invalidated essentially the identical state provision in the Texas context. And Roberts is actually quite open. He says, look, this is just a do-over of that earlier case. And we have a doctrine of stare decisis, which means once we have a decision, we don't lightly overturn it. Stare decisis here is too strong for me to go the other way, even though I voted in the dissent in Whole Women's Health. So this is a case where Chief Justice Roberts is very consciously and explicitly behaving with a kind of institutional mindset. And one way to understand what's happened this term is the Chief Justice is listening to especially the liberal criticism of the court. And he's listening to the talk of adding new justices, packing the court, right, which has become a thing in certain parts of the left. And he's heading that talk off at the pass. He's heading it off by showing that the court can be a centrist institution, that the court can be sensitive to all interests.
Mm-hmm. In fact, I think you can make that exact argument perhaps also for the DACA case called Department of Homeland Security versus Regency of University of California, right? I think that was another sort of 5-4 where Roberts came in to protect those who are claiming DACA protection.
Yeah. So that was a surprising vote that he cast. Notice that the issue in the DACA case is, did the Trump administration dot its I's and cross its T's for the purposes of administrative law, right, which is the law that governs how federal agencies behave? Did it do its administrative law homework before it invalidated DACA? And Roberts essentially says, no, they didn't. Last year, some of you may recall that the court invalidated the effort to put a citizenship question on the census,
right,
very much on similar grounds, and actually by the same vote, 5-4 vote, right? That the government just hadn't dotted its I's and crossed its T's. So yes, I think one thing that's going on is that Roberts cares about the institution, and some of his votes seem to reflect that. But the other thing is he seems to be a kind of color within the lines person when it comes to what federal agencies can do.
Mm-hmm. Excellent. Aziz, I do have a question that was raised that people asked, and this is a more sort of functional question about the court, and that is, how does the Supreme Court decide whether to hear a case or decline a case? In other words, the whole concept of the writ of certiorari, how do they determine that?
Yeah. So it used to be that the court didn't have a choice. Up until the end of the 1800s, the court had what's called mandatory jurisdiction. So in every case in which a federal right was denied or a federal statute was struck down, the court had to hear that case. This mandatory jurisdiction is taken apart from the end of the 1800s up through about 1921. The justices themselves play a large lobbying role, persuading Congress to do away with mandatory jurisdiction. And today, almost every case that the Supreme Court hears is within its discretion to hear or not hear. So what happens is that a case becomes final for practical purposes in a federal court of appeals or a state Supreme Court, and then a lawyer, the losing party, files what's called a writ of petition for a writ of certiorari, asking for the court to hear that case. The court then has more or less unlimited discretion on how to decide which of those cases to hear, right? And it hears a very, very small number of the cases that it's asked to do.
Now, is this within the purview of the Chief Justice, or do the justices kind of get a vote on this?
So it is not the decision of the Chief Justice alone. It's rather done by vote of the court. And for a quick rule is you need 4 votes for a decision to be granted, or for a case to be granted and heard by the court.
Oh, so it's not even a majority. That's good.
Yeah, it's a submajority rule.
Yeah.
The actual process is a little complicated. Effectively, what happens is all the papers come in, and basically the clerks from almost all the chambers work together in a kind of pool structure. And every week, each clerk has, let's say, 15 petitions to the court, and the clerk will write 15 short memos saying, this is what this case is about. I recommend you grant or deny. Almost always it's a deny. And then the justices use these memos, which are called pool memos, to decide on the case, on what to vote on.
Mm-hmm. Terrific. Well, that's great insight. So Aziz, I think we're sort of coming to the end of our discussion here. I don't see any more questions, but I do wanted to kind of follow up in terms of my introduction about your writings and background, which is published a couple of books that looks like mostly dealt with presidential powers.
Yeah.
And I'm wondering, number one, what are you working? Well, let me ask you to follow up to that issue, which is you wrote a book that sort of says how to save a constitutional democracy.
Yeah. So,
do you want to give us an answer in a couple sentences?
I think the 2-sentence answer to that is, I'm sorry, accidentally hit the wrong button. The short answer is, first, it's very important to have strong institutions committed to the rule of law. Some of those institutions are democratic in nature, the process of elections, but a lot of them are actually non-democratic. So courts, independent prosecutors, auditors are all extremely important elements of a democracy. And having what I would call a rich ecosystem of these accountability institutions is the way you preserve democracy. And if you look at what the present incumbent in the White House has done, particularly with Inspector Generals, what we see is he's slowly been killing off a lot of this ecosystem. The second thing is one has to get involved, one has to learn about what the issues are, what's happening, and one has to vote. If you are of age, if you're entitled to vote, it's extremely important to get out there and do your civic duty, even at a very difficult time.
Great. I can't disagree with that. I mean, I think institutions are really, to me, they really represent democratic power. And you see that across many other countries, particularly smaller nations who have very democratic processes. It's because their institutions are very strong. Aziz, we do have a couple of really quick questions. One question, one is a sort of a request, which is, they said, excellent session, you need to do this weekly as the court comes out with decisions. So we'll see, maybe we'll have you back for another session, but maybe not necessarily on a weekly basis.
Yeah.
And then the final question has to do with the Oklahoma case, which is, does the Oklahoma decision now mean that Native Americans convicted of crimes will need to be retried in federal court?
I think it will depend on whether they can timely make essentially bring a habeas petition challenging the conviction that was obtained in state court, and whether they can timely bring a habeas action that has the effect of freeing them so that they can be retried, will depend upon Oklahoma's post-conviction law. And I am not afraid to say that I am not an expert in Oklahoma post-conviction law, which tends to be very complicated.
Sure. Okay, wonderful. Well, let me just say it's been a pleasure having you. I really appreciate you taking the time.
Oh, thank you so much for having me.
Yeah, this is great. And I think even though the term is over, we may have you come back just to kind of give other sort of information. Are you obviously with COVID, you're not teaching at this particular time, but when is your next sort of situation of teaching? Is it in the fall? And
Oh, in
is
the fall. Yeah, in the fall. In the fall.
okay, great. All right. Well, thanks again, Aziz.
Yep.
And we enjoyed having you. And thank you to everybody who joined in and listening and asked questions. We really appreciate you joining us for this session. I hope you guys found it informative. I certainly know I did. And I think I was better educated about some of these cases as well as the decision-making opportunity of the Supreme Court. So thanks again, everybody. And we'll look for you in a couple of weeks for our next Zoom seminar. Have a good day.